So yeah, we're here this week. We're really privileged to be asked to be a part of this and to speak on the legal side of dying and preparing for death. We decided this presentation we'd split into two distinct parts. One which is pre-death preparing, getting your documentation in order, what you need to think about, and then Alana, who specialises in estate administration, is going to take you through some of the key things that happen post-death, because we put a lot of effort into thinking about getting our will and all of that sorted, but when someone passes away, suddenly you've got all of this, all of these things that you've got to arrange, and seeing the lawyer and figuring out what's involved is really important to understand as well. At the end, we've got a question session, and these guys have just referred to us sticking around. People often have personal questions in this context, so please do feel free to make the most of having us wait around for a bit afterwards. I generally tend to find that we get a few lines of people that are waiting to have a bit of more personal kōrero about their circumstances. So myself, today you've got me, Jamie Bourke. I'm a director at Henderson Reeves. I work with a lot of clients in succession planning, so that's wills, trusts, enduring powers of attorney, getting all of those things in order. Alana Lyle is with a senior legal executive with us. She's really experienced in estate administration, property work. So without further ado, we'll get started on our presentation. I'm going to take us through pre-death. So we'll start off with, why do I need a will? Because we get asked that question a lot, and not everybody needs a will. If you don't have many assets, if you've got simply assets below 15,000, so small minor balances in a bank account, or no minor children, then sometimes you don't need to go to the expense of having a will. But people who do have significant assets, have more than 15,000 in any one particular bank account, share investment, they will need a will. And the reason that they need a will is to reduce costs and reduce stress. At the very top, so there's a whole lot of reasons why you need a will, and at the very top I've put this statement, which is really kind of key to message for you to take away today. Having a will hopefully reduce family dysfunction and stress post-death. So that is where lawyers tend to make the most of their revenue in estate administration, is in family disputes post-death. And you do not want that. We all want our children or our spouse, whether it's a blended family, whatever the situation is, we want them to have as stress-free process when it comes to dealing with assets, because it's a really stressful process anyway, dealing with the loss of a loved one. So we see it all the time, don't we, Alana? It can be something as simple as a painting on the wall to a big farm. People don't think straight, and people get misconceptions after someone's died. So not having a will can add to that, boiling pot of dysfunction that can come about. So if you have clear directions, you've taken good legal advice, so you've had a lawyer look at your situation and give you advice on actually perhaps you might not want to do that because they might bring a claim, then you can generally reduce to quite a significant extent family dysfunction. You also want to make sure that your assets go where you intended them to. Alana's going to talk a little bit about what happens if you die without a will in New Zealand, which we have a piece of legislation that dictates where your assets will go. If you don't have any surviving people, they can even end up with the Crown. So you want to be really careful about making sure that they end up where you want them to. So at the bottom there, I've talked about an intestacy, which of course Alana will touch on further. That's where you die without a will. So we want to avoid additional costs. There is extra costs if you die without a will, and there are assets that need to be administered. Alana will touch on that a little bit more, but it is not as straightforward as the situation where somebody dies with a will. So you do reduce costs, delay and stress by having one. If you've got minor children who are under the age of 18, then a will is really important to ensure that the guardianship powers that you hold in respect to that child, whether, guardianship powers are what schooling they get, religious education, where they live, all of those are guardianship powers. If you don't have a will, then those guardianship powers are not passed on, and it means you're leaving a bit of a battle between family as to who has the say. And that often ends up in court getting guardianship appointments. You also want to provide some direction and guidance for funeral wishes. I'll talk a little bit more about this later on. One of the big things messages we'll get through to you today is that it's okay to have it in your will, it's good to have it in your will, but the most important thing is to share those wishes with your whānau and family, because often we don't get called, sometimes a month after, sometimes longer, and at that point, it's all done and dusted, so your wishes that are in there sometimes aren't complied with. So there are some really formal requirements of a will. We must have it in writing, so there is a way to get some handwritten things at home probated, but it's very difficult, so must be in writing. It's got to be signed in the presence of 2 witnesses who are there at the same time. At law school, we looked at countless cases where people had 2 people there, but while they were signing, one darted outside to get something and came back in, the will was invalid. So there's really strict requirements with regards to making a will. And lastly, testamentary capacity. This is a massive one. So this is having the ability to understand what you're doing. So not leaving it till you're on your deathbed or you've got dementia or Alzheimer's to start making and thinking about your will. So you've got to have the necessary capacity to be able to do that. At the bottom there I've said if you don't meet those requirements, that will that you thought said exactly what you wanted to have happen will not be valid. So some pretty big consequences there. The perils of the homemade will, I guess as a lawyer, we're not here strictly speaking for generating revenue from people doing wills. As I said right at the start, we actually make more revenue out of the people who don't make wills or make homemade wills or don't take legal advice because of the claims that are made than the people that come in and actually get things in order. So what happens, and it's very common now, you can do a lot of stuff on the internet, or you can go and get will packs from certain places. If you don't meet all those requirements of validity that I just talked about, again, you can have an invalid will. The other thing that we've seen happen a number of times in our office is security issues. So we had one recently where we had a blended family, a second relationship. One of the partners had written a homemade will, left everything to his new partner. He died, they were overseas when he died. Children came into the house, got the will, destroyed the will. She knew that there had been a will, knew exactly where it was, but it was gone, never to be seen again. So security is really important with your will. We always hold the original copy of the will in our law office, and I'd say if you do have your own homemade will, you should lodge one with a legal office just so that it's there. The other thing that most lawyers will do is that they will search the death notices weekly, and we will run that against our cross-reference that against our client database, so that if we do see that we hold a will for someone who has passed away, we will contact the family and say, look, we're holding this will. Often people have gone to another lawyer, maybe changed it several times, but lawyers are actively doing that all the time. So security is a major. Another reason to just be careful of the homemade will, and perhaps an example is failure of gifts. So one of the key things with will making is that order in the will of gifts is important. So we quite often get someone who comes in and says, look, I've got my home and I've got 500,000. I want to leave my grandson the 500,000 and then my partner can have the rest. They don't die for another 20 years, and in that time they spend all of that money, and comes to the order of the will says, I want to give my grandson 500,000. Well, he gets the first bite of the cherry. So the partner will miss out on that. So thinking about order of gifts, getting advice around that, how do you think about, you might better structure that so that those don't fail. The other thing is the unintended consequences of the homemade will. Part of the Wills Act states that if you die and you have a spouse and no will, and perhaps you've separated from that spouse 20 years ago, but you never got formally divorced, you've got a new de facto partner now that you want to look out for, you don't do your will, that former spouse under law is probably going to have an entitlement to some of those assets. So unintended consequences are a massive thing, and lawyers will look at all of that. They'll ask you a whole lot of really personal questions about your relationships, your dependents, your moral duties, and basically to assess. And yes, it is more costly if you have a invalid will. So yes, I said before, testamentary capacity is one of the big things we look at. Don't leave it till the very last minute. You must understand the nature of making a will. So if we have a client that comes in, and we do have this happen occasionally, where children bring mum in, mum wants to change her will, she wants to cut out my brother, he's estranged, everything goes to us now. We have to be very careful about how we manage that situation, make sure that that person isn't under any undue pressure and that they have capacity to understand what they're doing. If there is a diagnosis of some type of disease that might impair your mental capacity, then that doesn't necessarily mean you can't do a will. It just means we have to be a little bit more careful. We have to get doctors involved. And I've been on several occasions, been to doctors' offices and signed up a will with the client, having the doctor present and being able to say, look, although this client walked out of the office and didn't even know who Jamie was, at the time that she signed, she knew exactly what she was doing. So that's very much the medical situation, and we have to be very careful that we don't cross our lanes a bit, but just bearing that in mind about how important it is to actually do it early and think about it. So yes, you've also got to be able to appreciate the claims on your estate, which we'll talk about shortly. So another misconception is, what does your will cover? And I think these days lots of people have very complex ownership structures. So they might have a trust, they might have company assets, they might have a property that they've bought for their son because their son couldn't get finance, but they think of it as their son. So there's all sorts of different little interesting ways that people hold assets. One key thing to understand with a will is it only covers your assets. It doesn't cover trust assets. It doesn't cover assets in your spouse's name. It also doesn't cover jointly held assets. And this is a real big thing for people to understand. If you have a joint asset, joint bank account, jointly held property, and there's two ways you can own property. You can own it as a joint tenant or as a tenancy in common. And you'll usually get advice on that when you register or purchase your property, but sometimes we forget about these things. We can't remember how it was owned. We just know that we own it with our partner and we think about it as equal shares. If it's a joint tenancy and you're in a blended family situation, we see this all the time, two partners come in, they've both got kids to a former relationship, they want to look out for each other, but then they ultimately want their half of that property, or what they see as their half, to go down to their kids. When we search the title and find out it's joint property, well then that's our trigger to say to them, doesn't matter what you write in your will, that is going automatically to your partner. And your partner can then decide where they leave that if they survive you. So understanding joint ownership is really important. The converse of that, and Alana will talk about it a little bit, is thinking about joint assets as sometimes being a really good way to structure your affairs if you want it to be simple. So if you are when nuclear family these days are not as common as they perhaps were with your generation, but if you want to leave everything to your spouse, then having joint assets is a really simple way for it to just flick straight through to them outside of the estate administration. So beware of the joint asset and beware of making sure that you look into how those assets are owned. Trusts, of course, if you have a trust, a family trust, that's going to be completely separate to your will. Anything that's in your trust will go in accordance with the trust deed. So it's kind of almost like you've got two baskets that you're dealing with when you're preparing for succession on those assets. Yeah, what to be thinking about when we're making our will. So one of the things there we talk about is the size of the estate. So we always ask our clients, what are the assets? What assets have you got? There's more likelihood of a successful claim being brought against a big estate than perhaps a smaller estate. So what we're looking at is what are the assets you've got. We've talked about how are they owned, actually delving in and checking that. I had a client last week with a life insurance policy who was quite amazed to realise that actually that life insurance policy was owned by her husband's trust, not by her at all. So when she wanted to leave that to her children, those funds were actually going to go into his trust. So, and you often set those life insurances up when you're doing something. Perhaps they were taking out a mortgage and the bank said you must have a life insurance because the loan's in his trust name. Let's have his trust as the beneficiary. But we forget about that and we move on with our lives, and it has unintended consequences later down the tracks. How are debts owed? So we talk about liabilities with our clients. Sometimes people have lent money to their kids. Do they intend that to be balanced up with the other children on passing, or do they want that child to get that gift and then still get an equal share? Have you got joint debts? Jointly held assets are just the same as jointly held debts, so you can pass on your debts by survivorship too. So you've got to be careful about that. One of the key things that we always talk about with our clients is who are your dependents? Who are your likely claimants? Who have you got moral and legal duties to? And I'll talk a little bit more about the actual legislation later and possible claims, but families are complex these days, and asset bases are sometimes small, so it's very difficult to try and balance out looking after a partner as well as providing to children from a previous relationship. So our big complexity these days is managing the blended family, and they're everywhere. And the Law Commission's doing a big review on all of this succession law at the moment because they've realised that our laws are very much designed for the nuclear family, which no longer really exists in New Zealand. So we're working within that vacuum at the moment of trying to balance out how do we look out for children from prior relationships as well as discharge our duty to spouses. So quite complex stuff there. One of the things that you need to think about with your will is you've got to appoint an executor. Now, an executor, I don't know if any of you have been executors before, but essentially it's a big job. You basically are the one that goes to the lawyer, you sign all the legal documents, you apply for the probate, and then it's your job to call in all the assets, pay out all the debts, and then distribute to beneficiaries. But in a dysfunctional or stressful situation, family situation, you're going to have beneficiaries flying at you, left, right and centre. And so what we often say to people is we talk about who are your dependents, tell us a bit about your family, how do they get on? Do you get on with the children from the former relationship? Because those are big triggers to figure out who is the appropriate person to sit in this role. Sometimes if you have a very dysfunctional family, I had a client a couple of weeks ago who had 3 sons, one had a drug addiction, was a really lovely guy but was very up and down and difficult to deal with, and she wanted to choose her other 2 sons to act as executors. So we had a really big talk about, is that going to be a nice situation for them? What happens when he's not in a good space and that you're giving them the role of having to dish out money and will withhold money? So actually thinking about what is going to be involved, who is the right person. You can appoint more than one person, and sharing the burden is sometimes a good idea. You don't want to have all 4 children. I think that's sometimes a bit complex, isn't it, Lana? If you've got overseas people that you want to appoint as executor, that can also be a little difficult. It's not impossible, and we do come across a lot of clients that all of their family is overseas, and so that's an inappropriate appointment. And also the other thing is, if there is a lot of disharmony or you've got no one here, that would be appropriate. Look at perhaps appointing a professional executor. So you've got your corporate trustee companies, public trust, perpetual guardian, who do those types of services, but also lawyers and accountants will act in that capacity as well. As you would expect, the only clincher there is that there's cost involved where you've got a professional. But if you've got a highly complex situation and claims are likely to come left, right and centre, then that's a really good way to take your loved ones out of that arena and just put someone else who's objective, who really is just doing their job and doesn't have any connection into the family that they need to consider. What else can you include in your will? So testamentary guardians, as I said before, everyone who has children has a 50% guardianship right in respect to that child. Each parent has a 50% say in guardianship decisions. And so it's always a good thing if you've got minor children to think about who you might hand those decision-making powers onto. I quite often say to people, because this is a real tricky one for young families, they often have to go away and think about this for a month, and the conversation between the partners is usually quite entertaining because, you know, one will suggest someone and they'll, oh, no way, I can't imagine them looking after our kids. I always say to clients, it doesn't mean that's the person who is going to be having the day-to-day care. It's the person that decides where the day-to-day care goes. And also specific gifts. So we have a lot of clients that have, I guess, special personal chattels, taonga, monetary gifts, gifts of land that they want to make. You include those in your will, and we will help you to order those in a way that's not going to prejudice certain people, and also to ensure that they end up going where you want them to go. Firearms, I guess, is another one that we've recently had a bit of interesting thing with. Lots of people like to leave their gun to their nephew or son, but if they don't have a firearms licence, then you can't leave it. It gets taken by the police. So you've got to be really careful about making sure that the person you're leaving your firearms to has got a licence, or at least is getting themselves sorted for that eventuality. We also include in your will where you intend the balance to go, and this is where we're starting to look at balancing up the obligations that you've got to children, to your partner, to your spouse, and in what shares, how you do it, whether you set a monetary figure now, but if you state an amount in dollars and cents at this point in time, what's it going to look like in 10 years' time? Or should we use a shares ratio where you say a quarter, a third, whatever? Just a little word on legal control over your body post-death. So that legal control of your body and the decisions about whether you're buried, cremated, what happens to you post-death, those vest legally in the executor. So again, another thing to think about when you're appointing executors, who is the right person to be making those decisions. And those funeral preferences that you put in your will are just a statement of your wishes. So if you choose an executor who's got other thoughts about it, they get the legal right to make those decisions. Organ donation, I just wanted to make a little word about that. It's a kind of one of those things when you're applying for a new licence, you either tick the box or you don't, and you don't think a lot about it. The most important thing is to advise your whānau and family exactly what your wishes are, because it will happen really quickly in emergency or end-of-life situations where the doctors will suddenly be saying, do you want to consider organ donation? So it can be quite confronting for families. So if you have wishes, I think it's really important to make those clear to your kids, maybe even write them down, or whoever your loved ones, so they know exactly what you intended in that regard, and you're taking that pressure, I guess, off them making those decisions. In summary, it is easier and less expensive to die with a will than without, so do consider getting one. If you do your will, you still need to review it regularly. So life changes. There's some key reasons why you might change it if you have children, if you enter a new relationship. If you're separating, getting married, moving into a retirement village, all of those are good reasons to review your will. We've talked about keeping it safe, making sure that people can't whip in after you've died, get rid of your will, have it lodged with a lawyer if you can, just so that it's kept in a really safe place. Really important to let your executor know that they are appointed, so there's no big surprise. And I also encourage clients where they have a functional family to actually share what they're doing with their family so that, again, there's no surprises. They know that Brother John is going to be the executor and they know what's going to happen, that Dad's going to look after his new partner, leave her a life interest, but ultimately we're going to end up with something so that you don't have to have those awkward conversations. And also letting your whānau know your funeral preferences, because that all happens really quickly.